On PM Express tonight, this conversation is taking the country by storm in the last few hours. Parliamentary immunity, should current regime be varied? Trust me, this is not the first time we're having this conversation, but what has transpired in the last few hours is really unprecedented in the wake of all that has happened. Two arms of government clashing over such a pertinent constitutional matter. And it's all about this man here, an MP for Parliament, Member of Parliament, Boku Central, and Accra High Court today ordered that the Boku Central MP Mahama Yariga must show up for trial when he is required to do so at all costs. But there are issues. It's not as simple as saying this. Why? The court rejected a certificate issued by this man, who is the head of that other arm of government. I'm talking about the legislature, the Speaker of Parliament, right? To excuse Mr. Yariga, due to work in Parliament. Again, we haven't seen that before. Now, the MP is in court on various charges relating to, several crimes, including tax evasion. Now, per the court's ruling, as we've heard today, the Boku Central legislator is to return to court on Monday, June 10th, irrespective of whether Parliament is sitting or not. And the judge was absolutely clear to him today that she and she alone will decide when he shows up in court and not Parliament. That is always fascinating. Now, the minority in Parliament disagrees with the court's decision. They've actually indicated tonight that they will be heading to the Supreme Court. The MP has served notice of being unable to show up in court due to parliamentary proceedings, and he was quoting constitutional provisions. Now, the Office of Special Prosecutor had filed 2 cases against the Boku Central MP. Now, this is to the background of the case. What are the cases? One relates to procurement of ambulances, where the Special Prosecutor has raised some questions about that the Special Prosecutor is investigating. The second relates to tax evasion in importation of some 3 V8 vehicles. Now, on his next appearance in court, the court will determine an application, praying it to strike out some of the charges against Yariga. Of course, Yariga's people are questioning the charges. So the fundamental question is, and on the back of what has happened today with the legislature and the judiciary clashing on this matter, one rejecting the other's ruling, should we do something about the immunity granted these MPs in the Constitution as far as criminal proceedings are concerned? That is the conversation we are having tonight. You want to stay with us. I have the guests with the knowledge to help us dissect this. Stay with us. After the break, I'll introduce them and then we can get to the details. Live on PM Express tonight, my guest in the studio, Yaopon, is a private legal practitioner. James Agaga is a ranking member on the Defense and Interior Committee of Parliament. He is a member of Mahama Yariga's legal team. He is, of course, a former deputy interior minister as well. He's been in court today on this particular matter, both in Parliament and in court. So he's a man with wearing both hats today, but best person to talk about on this matter. We'll be joined also via Skype, Justice Sermsai and the law lecturer Gimpa will also join us as we dissect this all-important matter that this nation is seized with. And my surprise is really that this very controversial clause in the Constitution had not gone to the Supreme Court yet for interpretation. It appears this will be the tipping point that will get the Supreme Court involved in settling this matter once and for all. But let me start with you, James Agaga. So the judiciary, the High Court, almost rejected the Speaker's certificate. Not almost, did reject the Speaker's certificate. You're unhappy with that, but the court, as I've heard today by the lawyers, was well within their rights to do so. The law is in the bosom of the judge. And as of the time that what the speaker did was irrelevant. The certificate that the speaker brought was absolutely irrelevant. The judge should have the right to assess the certificate on the merits of the law. And that's what she did, and came to a conclusion that that certificate was irrelevant and did not apply to the case. What's your reaction to that school of thought?
Well, Evans, to start with, what the speaker did was not irrelevant. Remember that the issue of privileges for members of parliament is contained in the 1992 Constitution, as well as the standing orders of parliament. In fact, what the standing orders of parliament does is to lift verbatim what is captured under the relevant provisions of our Constitution. And you know, it is the province of the Speaker of Parliament to interpret our standing orders and to enforce them.
Yes, standing orders, not the law.
And well, it is even not right. It's not correct to say so, because the Constitution is the fundamental law of the land. And so, when Parliament decides to exercise its legislative power, we do so with the Constitution in mind. Because remember that we cannot pass laws that are in conflict with the Constitution. So at all times, we are guided by the letter and spirit of the Constitution.
But what the Speaker did today was quoting Articles 117, 118, seeking to rule on these matters.
To send a message.
But that's not his domain.
That is not true. That is not true. If the Speaker of Parliament cannot pronounce on
matters of law,
on the privileges, those matters of law actually captures the privileges that members of Parliament, including the Speaker himself, are supposed to enjoy. And so where there is an allegation of a breach of those privileges, remember that Parliament has its own mechanisms to enforce or to ensure that the privileges are complied with at all times. And so if you look at Article 122, Parliament can exercise a quasi-judicial function by meting out punishment for contempt for those who breach the privileges that members of Parliament are supposed to enjoy. And when it comes to the exercise of our power to commit for contempt, you see, you don't need to have recourse to a court of law. Parliament on its own can commit for contempt and even send you to jail. So sometimes Parliament can act in a judicial, quasi-judicial capacity.
Did they apply in this case?
Well, in this case, nobody has been hauled before Parliament for contempt.
Yeah, but your member of Parliament was being hauled before a court of competent jurisdiction.
Absolutely. At the time when he was attending Parliament, and that is what the Constitution says in Article 117. It talks about the fact that you cannot serve a summons, be it civil or criminal, on a member of Parliament when the member is attending Parliament or is coming from Parliament. Okay, you cannot. And Article 122 says, if you resort to conduct which can impede a member of Parliament from performing his functions as a member of Parliament or the institution of Parliament as a whole, you are in contempt of Parliament and you can be committed for contempt as a result of such behavior.
You've raised this matter of contempt. You've raised a scepter that either the conduct of the court, of the trial judge, or the conduct of the special prosecutor in this case may amount to contempt.
Absolutely. And let me say that without any fear of contradiction. But you see, if we stretch the matter to that extreme, we're going to set Parliament on a coalition course with the judiciary.
That is not healthy. You've already collided
today. That is not healthy for our democracy.
You have already collided today.
Well,
for the first time, as far as I can recall, a judge rejected the Speaker's ruling and threw in his face a certificate that he signed and brought to his court.
Well, I have a different
Has that happened before?
I have a different view about the ruling the judge delivered this afternoon relative to the Speaker's certificate. The Speaker issued a certificate to indicate that the Honorable Mahama Yarega was attending upon Parliament, all right, and therefore he should be clothed with privilege or immunity. unfortunately, the Speaker's certificate cited Article 118.
What does it say?
And 118 actually talks about the situation where the summons is meant to get the member of parliament to serve as a witness. So if you look at the heading of that particular provision, it's captioned as witness summons. So the position of the judge was that what the court, or if you like, the nature of the summons that had supposedly been served on Ayaraga, and I use my words advisedly, supposedly, because Ayaraga was never served with any summons until he showed up in court in the afternoon. So even when the judge made the order that the counsel for Ayaraga should produce him by 1 p.m., there was no legal basis because he had not been served with the summons to start with. But service of the summons should form the basis for a court to either issue a bench warrant if the accused person fails to show up in court. But in this particular instance, even as at the time the judge made those directives or orders, there was no service. There couldn't have been any proof of service. So Honorable Ayaraga actually came to court voluntarily out of respect for the judiciary, for the court, but not because he had been served with any summons. But Evans, having said that, let me put in proper perspective the issue of parliamentary privilege. Many people think that members of parliament hold themselves over and above the law, and that is why we're quick to latch onto provisions in the Constitution on privilege.
That's true.
That is not true. Evans, we need to be guided by our own constitutional history. Those provisions on privilege are meant to protect the institution of parliament against an overbearing executive. An overbearing executive. And so when I take you back into history, in the 16th century, the conflict between the monarchy and the commons. Remember the House of Commons had to fight. There was the Glorious Revolution, which actually made Parliament supreme and not the monarchy. But at that time, the monarchy was in the habit of using the criminal law to suppress critical voices within the commons. So if you were a critical legislator, they'll simply just bring up some trumped-up charges against you in order to silence you. So the issue of privilege evolved at that time to protect the integrity of and independence of the institution of parliament. And so when you find those provisions in our constitution, that is the intendment of the framers of the constitution. It is not to place parliament or parliamentarians, for that matter, over and above the laws. We are all equal before the law. But for that institution to be independent of an overbearing executive, it is important that those privileges are extended to us. In any case, the privileges are not saying that we should be immune from court processes. What the law seeks to do is that whilst the member is attending parliament or is coming from parliament, he or she should not be saddled with summons from court. And that is for justifiable reasons.
We'll interrogate why that is justified, and there are calls already for that clause to be looked at again. But, Yapon,
yes,
this is a very interesting day.
Indeed.
This might eventually end up at the Supreme Court, but it's what's your own reaction to what has happened? What's your initial comment on this?
Well, thank you very much. It's interesting indeed. And I think this is the way to test the Constitution and the principles on which these provisions are founded. In the first place, we also need to keep in mind the fact that our conduct may sometimes be akin to the exercise of judicial power, one way or the other. Anytime you take a decision that may affect positively or adversely the rights of a person, you are in a way engaged in what judges do. But in the wisdom of the framers of the Constitution, they have included a very important provision in the Constitution that any of us can exercise judicial power, But final judicial power resides in the judiciary.
Okay.
And so Article 125, Clause 3, states that the judicial power of Ghana shall be vested in the judiciary. Accordingly, neither the president nor parliament, nor any organ or agency of the president or parliament shall have or be given final judicial power. And so, yes, the speaker, in what he did today and almost regularly when they meet, and the rulings that the speaker gives, he is engaged in what judges do. He's actually exercising a power that is akin to judicial power. So there's no doubt about it in my mind. But that power is subject to the judicial power. And so what the speaker, or even you as a member of a committee that looks into conduct of maybe employees of this place, when you do that, you are exercising a kind of judicial power. Even if your own constitution here says that that is what you say is final, it is not final. And so what the speaker does on regular basis, when he rules this way or that way, is a judicial, he's exercising, in my view, judicial power. Some will say quasi-judicial power.
But subject to the final authority of the
the
court.
final judicial power is not vested in any individual, not even in a judge. It's in the judiciary. And that is because it is of all the three arms, what they call arms of government, I call it branches of state. It is the judiciary that we are specifically told, or we've told ourselves, that justice emanates from the people and shall be administered in the name of the republic by the judiciary, which shall be independent and subject only to this constitution. And so we exercise, it goes on to say that citizens may even exercise popular participation in administration of justice. That is what we do, but except that all of us cannot go to the court and sit as judges. So we have vested part of these powers in individuals or in an institution called the judiciary, which exercises final judicial power. Of course, at the judicial level also, final judicial power is vested in the Supreme Court in this country. So it's an interesting matter that is coming up. But coming to what happened, as my good friend said, there should be no confusion. People think that the legislature, or what they were urging us on, they were trying to impress on us that they are immune from prosecution or judicial proceedings. To my mind, there is some immunity from prosecution that has been extended to the president. And even that one, some of us hold the view that civil or criminal proceedings may be commenced against the president. I know this is controversial, but it may be stayed. Again, it is not the remit of anybody, from the president to the lowest of the low like myself, to question a judicial decision, except in the court itself. And so there's a famous case, Espati Afoda, that no one has the power not to obey even a void order of the court. So you know that the order that has been given is void. The court didn't have jurisdiction to give it. But you cannot question it. You have to obey it or go to that very court or a court that has appellate jurisdiction over that other court to have it set aside.
So when the court today said, I won't proceed with this case until Mahama Yariga is brought, the judge was told, he's attending on Parliament. He says, I don't care. I want him here. Yariga should have just simply gone to that forum, gone to the court, and go to argue his case out.
Well, I think he
eventually did, but after kicking and screaming.
Well, I mean, it doesn't matter. We all have the right to express our views on decisions of the court. In fact, there was one case, Mensa Bonsu, where even the judges, Adadi in particular, said that sometimes we feel that the general public and lawyers in particular do not criticize our judgments enough. Okay. But we caution that they should use decorous language.
Now here's a trick question. One of the things the judge said today, Agaga, you were in court today, so tell me if I'm wrong. My reporter says, the judge said, henceforth, she and she alone will determine when he comes to court. She said that?
Yes, she said
She
that.
said, hold on, I'll come to you on that.
Right.
I'll come to you on that. I want to pick his brain on that.
Yeah.
Is that constitutional? Is that legal? Is the court within her, is the judge within her right to make that pronouncement?
You see, I usually don't personalize
Let's say the court.
judicial proceeding.
Yeah.
So it's the court.
That's right.
Okay. Can
That
the
is
court
what-
say that?
Look, there are authorities.
Knowing what the Constitution says about
there
it.
are authorities that if a judge has the jurisdiction to make right decisions, it also has jurisdiction to make wrong decisions.
That's right.
Is this one wrong or right?
It is that same court. Why is she wrong? Why is the court wrong? The court is saying that it is within my remit to determine which dates, the manner, and the manner by which I will go ahead
But see
with
that
this
he's an MP,
particular
member of
case.
parliament.
No, you see, that is where the danger may be. Let's not put colors on persons who appear before the court. The court is there, and I think maybe we are the luckiest of all human beings on earth when it comes to judiciary. We have very bold judiciary or judges who are even independent of the judiciary itself. So there was one case when the Chief Justice, not currently, years ago, asked a judge to hold on with a case he was hearing because a complaint had been made. He said, when I sit as a judge, I don't take instructions from anyone, not even the Chief Justice. You understand? That is how lucky we are. And so there should always be assurances to the general public that it doesn't matter who you are. There are judges who are bold and independent-minded, who would look at the matter according to the law, the facts, their conscience, and their oath.
But you've made a very important point. According to the law. So this particular pronouncement by the court, does it satisfy the constitutional dictates as it governs the conduct of an MP who's facing criminal charges?
Well, number one,
Should the court, can the court say in the face of the Constitution that only the court can determine when a sitting member of parliament, whilst parliament is sitting,
well,
determine that when-
inherent in that is the fact that the judiciary has the final judicial power and the final say on anything that is, any dispute that is resolvable by law.
Interesting.
That power is not, and we are so lucky that it is with the judiciary. You can imagine if somebody else were to be given that final judicial power. Because luckily for us, there also, as I said, a single judge sits at the High Court. If you are dissatisfied, if at the moment you think that a judge is wrong, you go on appeal. One of the most important potent tools by which we criticize judges is appeal, or sometimes judicial review. Anytime you appeal against a judge's decision, you are criticizing the judge that she was wrong in the face of the law and the facts. And then from there, Court of Appeal, you cannot tell them, my lords, you were wrong. You say that you are aggrieved by the decision. You go to the Supreme Court. Of course, beyond that, that's the end of your matter. But then you will not appeal against a case unless you are dissatisfied with the decision. And you, by filing the appeal without sounding repetitive, you are actually criticizing the court, that the court was wrong.
So are you saying that if they disagree, they should go and challenge?
That is, in fact, there are two procedures, maybe three. You may go to that very court because the law also, and everybody knows, is that a court has an inherent duty to set aside its own void decisions, whether or not it is raised by any party.
But is this decision void? You think it's wrong?
I don't think so.
You think it's right?
But I think that what I think is, my view about it is one, that judges have the power to make decisions.
Okay.
As I said, the decision may be right or wrong. You cannot question it. The only means by which you question it is to go before that same judge, point it to him that, my lord, in view of this law, which is binding on you, whether by statute or by a judicial decision of a higher court, so set aside your own judgment. There have been instances where judges have reconsidered their own decision. Even there was one that there was no application. The judge just told the parties that I think I was wrong. I've set aside the decision.
Okay, I want you to. I know you have a lot to say on this last point, but I'll bring you in because I've just been joined on Skype by Justice Surnside, who has. Mr. Strike, thank you for your time here on PM Express. I'm sure you follow the conversation. I know you all have your thoughts on this. Where do you stand on the question? The last question I asked I think for me, is one of the areas you haven't explored. When the judge tells the lawyers, and Agaga was in court, that listen, I am the only person, but the court is the only body or entity that will determine when you come to court and when you do not come to court. Is the court right, legally under the Constitution, to make that pronouncement?
Thank you very much, Evans. And let me say good evening to my learned friends in the studio and to your listeners. On that specific question, the judge is right, and I have no reservation about that. And I'll explain why. When a summons is issued for a criminal prosecution, a summons does two things. First of all, it informs the accused person on the reasons for bringing him to court, that is, the charges. And then two, it commands him to appear at a particular place and time to stand trial. If you marry this to the privileges of an MP, the provision that we are dealing with says that the MP should not be served the process to appear before court unless when he's on his way, to Parliament. And as to whether he's on his way to Parliament, is the Speaker who has the final say. The practice over the years, not just in Ghana, but other jurisdictions, is that whenever there's going to be a prosecution, the prosecutors notify the Speaker of Parliament, who then decides whether to release the MP to face charges or not. Now, the question here, as you can see, is that the prosecutor has duly notified the Speaker of his intention of the summons. Now, until the time that the accused person appears in court, the Speaker has a say. The accused person also has a say as to whether he will avail himself. Now, we know that Honorable Ayariga was not served at the time he appeared in court. But you see, the moment a person honors a summons, whether he has been served officially or not, the moment he appears in court, the issue of the service is dealt with. Because then your coming to court tells us that you are aware of the charges, you are aware of the place and time to appear. Now, what happened today, to my mind, tells me that Honorable Ayariga, by appearing in court and speaking to the judge and responding to the summons, whether he has been served or not, has waived his right to that privilege we are talking about. Because once you cross that stage of appearing before the court, Article 117 and 1182, ceases to apply, because that is the only immunity you have to appear. But once you appear, then the judge is seized of the matter, and the entire, prosecution is within the court.
But
and
the judge
Parliament
insisted.
cannot overreach.
Did we have a choice? The way the judge was insisting today, that at 1 p.m. show up, I'm demanding that you show up. Did Ayariga have a choice in the matter?
Let me tell you something. If Honorable Ayariga did not send any lawyers to court, the judge would not have said that. Because then there will be a legitimate reason why he's not there, because he has not been served. But the fact that he has sent lawyers to court tells the judge that he is aware of these summons. So the first step of waiving his right to that immunity is when he dispatched lawyers to appear before the judge, even though he has not been served. So once the lawyers are there and are there to represent him, the issue of service of the summons, has been dealt with. And it happens in civil procedure as well. If you have been, you are a defendant and a writ has not been served on you officially, but you are aware of the writ and you appear in court, the essence of the writ is discharged, because what we want is for you to appear. You understand? So I don't think there's actually any issue there's no collision between the courts and Parliament as at this time. There would have been a collision if Honorable Ayariga did not send anyone to court and did not go to court and rely solely that, look, I have not been served, and even if I have been served, my immunity is still in place. But by appearing, he will be deemed to have waived the right to the immunity. And from that point in time, the judge has absolute charge of the case and will determine when he comes to court. And that is the essence of the immunity. Once you waive it...
Justice, hold on for me. Let me bring in one of Ayariga's lawyers, Agaga. What's your reaction to that? I know you also want to substantively respond to...
Yes. Evans, I think, you see, the provisions of the Constitution must be read as a whole. If you take Article 117, and I think that is the provision, the Council Justice Stry, is talking about. It's on immunity from service of process and arrest.
Yeah.
But what effect does the provision here seek to achieve? You wouldn't know the effect until you have read that provision together with 118, even 119, and 122. 122. So the purpose, the object, the combined effect of the provisions I have mentioned seeks to achieve is to prevent, persons other than Parliament itself from obstructing members of Parliament from carrying out their parliamentary duties.
And this might include the court.
So, absolutely. Absolutely. The language of Article 122 is very clear. It's very clear. It says, look, an act or omission which obstructs or impedes Parliament in the performance of its functions, or which obstructs or impedes a member or officer of Parliament in the discharge of his duties, or affronts the dignity of Parliament, or which tends either directly or indirectly to produce that result, is contempt of Parliament. And that is why I made the earlier submission that the purpose of these provisions is to protect the institution of Parliament itself.
It says you waived your immunity.
From an overbearing executive.
It says you waived your immunity.
I don't think so. The immunity was waived.
Justice, I'll come to you shortly.
The immunity was waived in respect of the service, because Honorable Mahama Ayariga appeared, and once he appeared, the court itself, the bailiffs, took advantage and served him in court.
Yeah, so that's a point.
In court. But beyond the service itself, if you're saying that, yes, it is now the remit of the judge alone to determine when and how.
You disagree with that? The two lawyers agree on that.
The judge must take account of the provisions in 122. And that is what the ruling of the Speaker this afternoon actually...
So, Clive, you're saying that as far as the Member of Parliament is concerned,
yes,
it is not only the domain of the court to determine when he comes and when he doesn't come.
So the domain of the court comes in, yes, they will determine, but they must do that in a manner that will not impede the member
on his constitutional rights.
Absolutely, from representing his people.
But I'll come to justice. But another question, follow-up question.
So the judicial function they would exercise is also subject to the Constitution.
So my question to you,
we're saying that those are the provisions we have invoked.
My follow-up question is, this particular pronouncement of the court that I alone can, does that contradict the Constitution?
Or subject to the Constitution. If you say I alone, as if to say...
Yes, but remember, what did she say? What did she say exactly?
Yes. She says from henceforth she alone would determine when the case
is that constitutionally right?
That is constitutionally right, but that must be done in consonance with the Constitution itself.
The way it was done today,
in a manner that would not impede the member from exercising his functions as the representative of the people of Boku Central.
Okay.
If fixing court dates, right, would impede Mr. Ayariga's exercise of his functions as a member of Parliament, then Article 122 would come in handy.
Okay. So I'll come to shortly because it's on the line. Justice, yes.
Yeah, Evans, I think substantially, my learned friend, the Honorable, agrees with me. And he agrees with me in the sense that, you see, once the service is done and you are aware of the process and you have availed yourself to the court proceedings, then the court has absolute control. You see, it is not different. If I'm facing the court, there are situations where I may not be able to attend court, even as an ordinary person. And I may indicate to the court that maybe I have a medical situation, or maybe I'm traveling, or maybe I'm attending a funeral. And the court, most of the times, unless I abuse that process, would allow me. Going forward, that is what is going to happen. If Honorable Ayariga, has a sitting, it is a question of notifying the court that on this agenda date, we have this particular thing to do in Parliament. So I may not be able to come. And the judge would, understand and grant.
No, but isn't that what he did today? And the judge didn't understand. That's what happened today. The lawyers in court told the judge that the man is in Parliament, is sitting. Wrong. And the judge said, I don't care.
And that is what it is.
So bring him before me.
No, you see, the judge understood. That is why he even stood down the case to 1 o'clock. Otherwise, then the judge
that's the point. The judge said, I'm standing down for you to bring him before me today. I don't care whether he is in Parliament or not. In fact, the Speaker then gives us a certificate to go and show that he is working. He threw it away because on the evidence of the law, it was wrong. It wasn't applied.
When I followed what happened in the court, my understanding, this is what happened. Okay. The speakers noticed that he was on the floor, for which reason he did not come in. It was to give some kind of excuse duty that, look, he was not there earlier because he was on the floor of Parliament, right? That in no way defeats what the judge said. Because even as an ordinary person, if I am late to court or if I'm absent in court and I have a justifiable reason, the judge will listen. That reason has in no way taken away the judge's absolute 100% control over the proceedings. You see, so personally, from my point of view, there is actually no dispute at this point, having waived the service of the process stage, because that is where the immunity is. The immunity is at the service stage.
But remember that today the minority has said, in fact, the minority leader said they're going to challenge the ruling at the Supreme Court because they believe it goes fundamentally to the constitutional provision. Correct, Ayagaga?
Yes. That's our position.
Okay.
Yes. And you see, what is fundamental?
Just hold on for me. I'll come to you.
Okay, sure. Yeah. You see, I think the point needs to be made that as at the time the judge ordered for Honorable Mahama Ayariga to be produced, there was no basis because he had not been served with any summons. I guess the service of summons is fundamental for the commencement of proceedings before a court, be it criminal or civil. In this instance, Honorable Mahama Ayariga, even as at the time the judge issued her orders, had not been served. So what was the basis of that order? And even at the time when he was attending upon Parliament.
Yapon, Justice, I'll come to Yapon.
Yes, I think let's make it clear that judges do what is reasonable. And I am certain that in subsequent proceedings, and no wonder she has fixed the next date on Monday, they do what is reasonable. At any point in time, in my view, at any point in time where Mr. Ayariga or Honorable Ayariga may want to give an excuse to the court will reasonably consider the conditions and the situation which may necessitate his inability to appear before the court. And I do not think that the court will in any way unreasonably restrain him from attending to Parliament or any other proceedings. They do it, as our friend said, on almost daily basis. Something about service. There are situations where even the rules of court permits that you can go and set aside a writ or service of the writ. So the mere fact that you've become aware of a suit is not conclusive of a waiver of your right to challenge even how you were served. So that needs to be clarified in my view. But the other point also is that once Honorable Ayariga appeared before the court, he was still entitled to question the mode of service on him.
So you don't agree that it was a waiver of his immunity to show up in court?
He can still decide. No, I don't think so. But he can still decide to even challenge not the court. Usually it's even in reference to the service, the persons who are given the power to serve. Now we can call them bailiff, the service providers, if you like. You can still question the mode of service because there's something called service out of jurisdiction. Whether or not the person has become aware, it's not conclusive that the service has been proper. The law is quite clear that you can still challenge the mode of service. In this case, I'm saying that at the same time, these initial proceedings should not in a way lead to a confrontation between the two important organs of state. I think that Mr. Ayariga, incidentally, was my mate, a very good friend at that. He is well equipped, and together with able lawyers, to understand that it is in everybody's interest, especially as lawmakers also, and as opinion leaders, that the least we do is to create in the minds of the people that Parliament or one organ of state is on a collision course with the judiciary. I mean, those of us who almost on daily basis go to the court or have something to do with judges, we have no doubt in our mind that the judges do what is reasonable. And in this particular situation, I am certain that any time that Mr. Ayariga has a justifiable reason, even in Parliament, if you cannot attend to Parliament, you give a justifiable reason. Otherwise, is it 15 sittings or so? Yeah. You can be sanctioned.
You lose your seat.
And so the same thing will extend to the court. But the impression that I believe the court didn't want to create or for people to perceive is because of his status, then because he's a member of Parliament, somebody too will come and say, I'm a banker. And you know, we bankers, from Monday.
Except that there's no law that gives that privilege to a banker.
Yes,
but in the case of the MP, there is.
But in the case of the MP, you see, the question is whether or not if a judge compels your attendance, the judge is impeding your attendance to Parliament.
But it depends on how that compulsion is done. Because he has to be constitutional. He has to meet the constitutional.
Of course. You know, in criminal proceedings, non-attendance of an accused person or a person standing trial can call for the issuance of a bench warrant.
So that's why the judge was insistent
to compel your attendance.
Should the judge have done that?
Well, I mean, Honorable Ayariga appeared, so that is
eventually.
It's a moot question now. But my point is that I have seen many instances where, for members of Parliament, proceedings in which they are involved, whether as witnesses or as parties, have usually been on Mondays because the court understands. Not that if the court asks you to come on Wednesday, the court is violating any law. But the law is a combination of the letters we see and the spirit.
Okay, hold that
and
thought.
It is in the spirit that the judges do what is reasonable.
Hold that thought. Justice, I'll take a brief comment and I'll take a break when I come back. How do we deal with this, controversy? Justice?
Yeah, so just before that, let me just quickly straighten up a point I was trying to make, which didn't come out clearly. Like my friend,
is it me?
Sorry. Upon Esquire said, until the time that the waiver, the alleged waiver or the imputed waiver is challenged, it will remain in place. So when Honorable Mahama Ayariga appeared, if he had raised an issue about the service, then we can say that he has not waived it. But as it is now, what happened today, on Monday, they are going to proceed with the motion they have already filed, which means that at least there's no immediate intention to question the waiver issue. Now, going forward as to what to do, I think that the procedure is well established. I don't think this is the first time this thing is happening. If a prosecutor wants to, prosecute, or even a civil case, if you want to sue an MP and you want the MP to appear, the procedure is well established. You write to the speaker seeking permission that this is what you want to do. Once that is done, then everything goes as usual. And I think what happened
in this case, I think that happened, right? The speaker was written to by the SP.
Yes.
Exactly. So I think that when I think about the whole thing,
but the did not make a decision on the SP's request.
Okay. Why?
To no, because we had to resolve the issues arising.
But I thought the speaker could just have written to the SP and say, yeah, I've allowed him to come.
No, there were quite a number of issues that needed to be resolved.
Such as?
Some of the issues, I don't think I should disclose them on this platform.
I'm curious.
No, because
the public is curious why. Because that would have stopped us from coming to this one.
By parliamentary
yes. I think it's not proper for me to do so, but I'm aware the speaker had some engagements with even the SP.
Okay.
Before the decision was taken by us, Lord Counsel for Mahama Yarega, that we should attend court.
Okay.
Notwithstanding the objections that had been raised. Okay. Remember that in the morning, today, Honorable Mahama himself on the floor,
yes,
raised the issue of privilege.
Yes.
And that was what compelled the speaker to interrogate the issues before that ruling was eventually delivered in the afternoon.
Okay.
So there were some few consultations here and there.
So that's why the speaker's decision on the SP's request delayed.
Absolutely.
Okay.
Yes.
Okay.
And remember, I mean, the point has been made by my senior Opong, time without number, that it's important that we don't set Parliament on a coalition course with the judiciary.
Okay.
I guess that is why the speaker even decided in his own wisdom to have some engagements with the SP before
in spite of all his efforts, he still got to where he got to. So the question I guess that most people are asking tonight is, this particular provision has caused a lot of trouble in the past. Yeah. I guess this one is, I guess, has blown because of the way the judge ruled and the speaker. So how do we avoid this from happening? I think your suggestion is that the Supreme Court give a proper interpretation once and for all on this. I'm going to take a short break. We're going to return. We'll see whether that solves the problem. Stay with us. So, you're still with us here on PM Express. My guest in the studio is Yao Pong, paralegal practitioner James Agaga, and on Skype is Justice Remsai. Mr. Pong, so this controversy keeps emerging. How do we make sure this is the last time we're having this conversation on this matter?
Well, thank you. I wish we will not come to that stage where there will be no controversy. For me, I
on this particular issue,
on a daily basis, we should take the Constitution and raise issues about it. That is how the laws develop. We say the Constitution, some say living organism, but others say every organism is a living being anyway. So it is somehow tautology. But it's an organism. But you need to ensure that you grow it.
So how do you settle this?
You have to tackle it. For me, there's no controversy. There's no ambiguity, in my view. There's no need to go to the Supreme Court. The language, in my view, is very clear. You see, the word used, one of the words used, the key word is process. In law, a process is not so much about the steps you take, which the ordinary meaning may suggest. But papers like summons, hearing notice, or mainly summons, the things we file in court on which proceedings are taken. These are the processes. But it also uses another word, executed. You understand? That, in a way, is akin to the enforcement of orders. So it is not only about service of documents from the court, but even arrest. So on the side note that he read, is service and arrest. So the use of the word execute or executed is also in reference to actual enforcement. So the provision is not only about service of court documents, but also in reference to arrest. When a person is going to Parliament or on his way from Parliament, he cannot be arrested.
Okay.
A court order cannot be enforced on him. But we have to, in interpreting a constitution in particular, we need to apply the purposive approach, and where we read it as a whole and find out what is reasonable. So is it reasonable that when a person is going to Parliament, he is arrested? Is it reasonable that when he's leaving Parliament, he's arrested? And Parliament in this case can be looked at broadly to even include going to his constituency to perform parliamentary duties, for example. But on these, I am very certain that there's no ambiguity.
Okay, so leave it as it is.
He may not call for parliamentary and any constitutional interpretation, except where the issue of the powers of Speaker or Parliament to interpret, to give decisions in reference to the Constitution and the standing orders vis-a-vis the court. And that's what happened today. The final judicial power
is the court. Let me hear you on this. You say you're going to Supreme Court.
Evans, a lot of people, lawyers, and I've heard Kwekwasari, Professor, and Professor Prempe ask questions about the propriety of Honorable Ayaraga's objections. And they ask certain fundamental questions that in the past, MPs were tried and convicted, and they were quick to cite the example of Dana Bodakpe and Damu Sakande. It's strike law. Okay? Fact that in the past people didn't raise these constitutional objections will not operate as a bar.
Otherwise, the law would never develop.
Right?
I mean,
against Honorable Ayaraga from raising those constitutional objections.
That's all.
That is the only way we can enrich our democracy.
Yes.
Okay.
We are of the firm belief that the issue of parliamentary privilege should not place parliamentarians
Above the law.
above the law. But at the same time, they are privileges that have been provided for under the Constitution and must be taken seriously.
Okay. So you're heading for the Supreme Court?
Absolutely. We have a strategy. The Speaker's ruling was delivered. It's very detailed. We would take appropriate strategies and at the right time decide on what to do.
Okay.
But our decision to test the law remains valid, and we're going to pursue it.
Thank you very much.
That's the logical conclusion.
Practitioner James Agaga is obviously a member of Parliament. My name is Evan Spencer. On the phone, on the Skype with us earlier was Justice Remsai, who is a law lecturer with GIMP. I'm grateful that you joined us, gentlemen. Enjoy your evening. My name is Evan Spencer.